G'day everyone, and welcome to the final video in week 4 of our admin law course. This week we're focusing on the grounds for review which are described as the narrow ultra vires rules, which really means that these are the rules where we test whether the decision maker had the power to make the decision that they made. In the first video, we asked if there was an enactment that gave them the power, and we asked whether all of the procedures had been followed which are necessary for a decision to be made at all. In this video, we're going to focus on the person, the decision maker. Section 5(1)(c) of the ADJR Act says that a decision can be reviewed if the person who purported to make the decision did not have jurisdiction to make the decision. At a basic level, this is pretty simple. There are lots of public servants who work in lots of different areas and who have lots of different ranks and grades. When the Parliament establishes an administrative power, that doesn't mean any old public servant can make the decision. If you want approval to open a new airport, you don't go and ask someone from the Education Department. Similarly, if you want a multi-million-dollar grant, your decision maker is not going to be the person sitting at the reception desk. That's not to denigrate the person at the reception desk either. It just means that people in different roles have different responsibilities. And so each decision must be made by the right person. How would you expect the right person to be designated? Well, you'd expect it to be in the statute, wouldn't you? And so it is. Let's go back to the learner driver logbook example we've been using this week. Regulation 32, sub-regulation 1 says a young driver may apply to the Chief Executive for approval of the young driver's completed logbook. Then sub-regulation 3 begins, the Chief Executive may approve the logbook. So who has the power? The Chief Executive has the power. Simple. But this is a law school. We can't let things be simple. Let's complicate it. We start with ministers. As you already know, ministers are elected members of Parliament who have responsibility for particular areas of policy. So you have an education minister, a health minister, a defence minister, and so on. Often, legislation gives decision-making power to the minister. Realistically, no minister is ever going to have the time to make all those decisions, and every minister has their very own public service department to help them. And so there's this concept called the alter ego doctrine, which means that wherever the legislation gives a decision-making power to the minister, that decision-making power automatically transfers to the Chief Executive of the Public Service Department. The Chief Executive is the alter ego of the minister. The authority for the alter ego rule is a case called Carltona and the Commissioner of Works, which was a case about the wartime requisition of a factory. It was challenged partly on the basis that the minister had not personally made the decision, and that challenge was unsuccessful. There are a few exceptions to the alter ego doctrine, but they're pretty few and far between. The second complication is the concept of delegation. Again, let's consider the driver licence logbook situation. We've established that the power to approve a logbook is given to the Chief Executive of the department. Now, there are about 60,000 17-year-olds in Queensland at any point in time. Even if their applications were all spaced out nicely, if every 17-year-old put in their logbook, that would mean the Chief Executive would have to review 164 logbooks every day, 365 days a year. That would mean, given an 8-hour workday, one every 3 minutes, 7 days a week, they wouldn't have time to do anything else. And so even though the power is given to the Chief Executive, it gets delegated to people who work for the Chief Executive. Now hang on, I hear you say. That defeats the point. If the Parliament gives the power to the Chief Executive, but the Chief Executive can just give the power away, doesn't that defeat the intention of the Parliament? Well, that's a good point. But what if the Parliament specifically gave the Chief Executive permission to do that? Well, the Transport Planning and Coordination Act contains Section 37, which says in part, the minister or the chief executive may delegate to a person a function or power under this or another act. And then section 123 capital D of the Transport Operations Road Use Management Act 95, which is the legislation that our logbook regulations made under, it says that section 37 applies. So the Parliament has specifically made a rule allowing the chief executive to delegate this power. There are hundreds of these delegations under hundreds of pieces of legislation. Each department has to report to the Parliament and make publicly available its list of delegations. So when a delegation is made, it's made publicly. The authority for all of this is a case called Proudfoot and Heriock, the Human Rights and Equal Opportunity Commission. I think Proudfoot was the surname of a family of hobbits in The Lord of the Rings, but I'm going to assume this is just a coincidence. In Proudfoot against Heriock, the applicant was cranky because the Women's Health Service in the ACT did not also provide a men's health service. And he challenged the decision to provide the Women's Health Service on the basis that the chief executive did not personally make the decision. The court found, fairly obviously, that there was a valid delegation, and so the decision need not be made personally. There's only one other thing we need to talk about here, and that's what we call the rule against sub-delegation. So let's say the chief executive delegates review of logbooks to a new type of officer called a logbook inspector. Now let's say that in Charters Towers there was a logbook inspector who didn't like work very much, and so they decided to call one of their staff an assistant logbook inspector, and they decided to get that person to do all the work. Can you see the problem? The person making the decision there is not the person specified in the legislation, but they're also not the person nominated in a formal delegation made under the Act. A person who has received the delegation must make the decision themselves. This is the rule against sub-delegation. So where does all of this leave us? We have this idea of narrow ultra vires. Narrow ultra vires is all about whether a decision maker has the right to make a decision at all. We know that they don't have the right to make a decision unless they can point to an enactment which requires or allows the decision to be made. We know that sometimes the enactment will require certain things to be done before the decision-making power springs into existence. And if those things are not done, then there's no decision-making power. Finally, we know that the decision can only be made by the person nominated by the Parliament. However, if that person is the minister, then the alter ego doctrine means they can pass the decision to their department, and in any event, the legislation might allow for decisions to be delegated. If a person receives their decision-making power from a delegation and not directly from the enactment, then they can't sub-delegate the power any further. There's one last concept that we need to discuss this week, and that's called a jurisdictional fact. This is an odd concept, which is why I've left it until last. A jurisdictional fact is a fact which must objectively exist in order for a decision maker to have jurisdiction. Now, it's easy enough for me to say that, but coming up with realistic examples is hard, partly because this concept of a jurisdictional fact was mostly useful before the ADJR Act. So, for instance, returning to our logbook example, we might say that the decision maker's actual or electronic possession of the logbook is a jurisdictional fact. If someone applies for approval of their logbook but doesn't actually attach the logbook, then we could argue that the decision maker's jurisdiction has not yet come into existence. And that makes sense well enough, but it's kind of already covered by the requirement to follow proper procedure. In this case, the procedure says the delegate can only approve a logbook if they're satisfied the requirements are met. It's impossible to see how that could happen unless the decision maker actually had the logbook. So understand that there are these things called jurisdictional facts, and they still exist, but we can think of them rather like mandamus. They're still part of the law, but their practical utility is diminished with the coming of the legislation. Okay, so that brings us to the end of week 4. This week we've started to look at the various types of error which can compromise administrative decision making. And we've started with narrow ultra vires or jurisdictional error. This type of error says that unless the power is granted by a statute and used by the right officer following the right procedures, they may not have the power to make a decision at all. Their decision is a nullity. Next week, we're going to spend some time with perhaps the most important and most enduring concept of administrative law. One of the most important concepts of law, full stop. It's called natural justice. See you there.